Good morning, Baroness.
Good morning.
Now let me explain the arrangements. You're talking here directly to an audience which contain participants and members of the public. On your left, there are lawyers representing various different interests in the inquiry. At the back, there's a representative of the press and some others. But beyond this room, you will be talking to those in a breakout room, but more particularly, and a larger audience online, watching either on YouTube or live stream, probably numbering in 3 figures somewhere. Ms. Richards will ask you the question in a moment or two once you've been sworn. Mary will invite you to take the oath in a moment. Mary.
Please state your full name.
Dawn Primarolo.
Repeat after me. I do solemnly, sincerely,
I do solemnly and sincerely
and truly declare and affirm that the evidence I shall give shall be the truth, the whole truth, and nothing but the truth.
Baroness Primarolo, I'm just going to start with a brief overview of your career. You became an MP in 1987, is that right?
That's correct.
Now, between 1992 and 1994, you were shadow spokesperson for health. What did that entail?
I was in a team of members of Parliament from Her Majesty's opposition, led by David Blunkett, who was the Shadow Secretary of State. And our role as Her Majesty's official opposition is to try and hold the government to account for its policies and the discharging of those policies through the health service.
Then in 1997, when the Labour government came in, you became Financial Secretary at the Treasury from 97 to 99, and then Paymaster General from 1999 until 2007. Can you just outline what each of those roles entailed?
Sorry, could you repeat the date again? From
Yes.
1997?
97 to 99, Financial Secretary at the Treasury.
Yes. After the election of the Labour government in 1997, I moved to being a Treasury Minister, a Minister of State. My responsibilities were in the area of taxation, and I covered a wide range of policies through what was then Her Majesty's Customs and Excise and the Inland Revenue. And I had responsibility for ensuring the development of policy as agreed with the policy team, and in particular the Chancellor of the Exchequer. That later became HMRC, Her Majesty's, I can't remember.
Revenue and Customs.
Thank you. Thank you for the prompt. And I was the minister that merged the two departments under policy development within the Labour government. So essentially, my policy responsibilities were the same, although my title changed to Paymaster General. Within that, I had primary responsibility for ensuring that the budget policy was developed and available for the Chancellor of the Exchequer then to agree or disagree with.
Then on the 28th of June 2007, you took up a role at the Department of Health as Minister of State for Public Health, and you held that role until the 8th of June 2009.
That's correct.
And obviously that's what my questions will be focusing on today. And just to put it into a broader political context, that was the point at which Gordon Brown succeeded Tony Blair as Prime Minister.
That's correct. Gordon Brown became Prime Minister in the June, and it was part of the reshuffle as he moved to number 10 to become Prime Minister.
Having spent approximately 2 years in that role at the Department of Health, you then moved to become Minister of State for Children, Young People and Families, and you held that role until the general election in 2010.
That is correct.
And then you remained an MP 2010 to 2015 in opposition, and then became a member of the House of Lords in 2015.
That is correct. From 2010 to 2015, I was elected a Deputy Speaker of the House of Commons, and I retired in 2015.
Now, in terms of your role as Minister of State for Public Health, you succeeded Caroline Flint, from whom the inquiry's recently heard.
That is correct.
In terms of the ministerial team, you've set it out in your statement, so if we just put that on screen, Lawrence, WITN 5494001, please, page 11. So we can see in paragraph 2.2, you've described the ministerial team during your time as Minister of State for Public Health. The Secretary of State was Alan Johnson, Minister of State for Health Services Ben Bradshaw, Minister of State for Public Health you, Parliamentary Under-Secretary of State for Health Anne Keane, Parliamentary Under-Secretary of State for Care Services Ivan Lewis and then Phil Hope, and then Parliamentary Under-Secretary of State in the Lords Professor Lord Darcy. And for the benefit of those following, we do have a statement from Mr Johnson. We don't need to put it on screen, but the reference is WITN 7197001. I think his time as Secretary of State effectively coincided largely with your time as Minister of State.
I believe it did, yes.
Now, you've told us, we can take that down, thank you, Lawrence. You've told us that policy making in relation to blood transfusion and blood products and hepatitis fell within your areas of responsibility as the Minister of State for Public Health.
That is correct, yes.
But you had a number of broader public health responsibilities as well.
I did, yes, very broad.
You've also told us in your statement that you had no clinical or scientific background of your own, and you didn't have a special advisor in your role as Minister of State.
I didn't have a scientific background, no, and as a Minister of State, I didn't have a special advisor attached only to me, no.
And so you've said in your statement you were therefore heavily dependent on civil servants' advice, but you describe your role as being to scrutinise that advice, ask questions, and elicit further information in order to reach a considered opinion. Is that right?
That is correct. That would be the role of any minister.
And we'll explore how that work played out in relation to issues that the inquiry is considering in due course. Do you have any knowledge of how different areas of responsibility were allocated to different ministers?
Could you be clearer
Yes.
what you mean by
that? In terms of blood transfusion, blood policy, hepatitis falling within your area of responsibility, did that come with the title of Minister of State for Public Health, essentially? Or do you know how it was decided and by whom that one minister would be responsible for one type of issue and another would be responsible for a different range of issues?
Forgive me, I don't think I can answer that question of how it was allocated to me. When the subject emerged, I was told it was within my brief, but it wasn't specifically listed. So I'm not sure I can answer your question direct.
In terms of interaction with the Secretary of State and your fellow ministers, were there regular meetings between ministers at the department?
Yes.
But would they be weekly or was it on a more ad hoc basis?
No, it would be on a regular basis that there would be a ministerial meeting. It was regular. I think it was approximately weekly. To be honest, I can't quite remember now, but it was very regular. Those would be the formal meetings where the ministerial team would be reporting back to the whole team, to looking at issues that were arising that we all should be aware of. And in addition, there would be informal one-to-one meetings with the Secretary of State as and when was necessary.
And to what extent did you have regular interaction with the Chief Medical Officer?
I'm afraid I can't actually remember that because I would see a huge number of officials. Forgive me, my memory doesn't. I can't answer that question.
We'll see from some of the documents we look at the role of your private office, and we've heard that explained by other ministers, and we'll see that your interactions with civil servants dealing with blood policy. At the highest level of the civil service in the Department of Health, the permanent secretary level, did you have much by way of interaction with the permanent secretary, or was that something that was essentially undertaken by the Secretary of State?
That relationship is essentially a Secretary of State's role. I can't say I never met with the permanent secretary on individual issues, but I would be speculating. I'm afraid it would, if you like, the flow of information would be permanent secretary to Secretary of State. I was lower down the pecking order.
Now, you've told us in your statement you had some knowledge of the position of those infected through blood or blood products with hepatitis and HIV as an opposition MP and from your constituency work. Apart from that, did you have any other particular knowledge of these issues, or did you receive any briefing on these issues when you took up your post?
The knowledge that I had came more specifically from my role as a constituency MP, and I do not lay claim to that being extensive from what constituents would have told me. In terms of, if you like, a position briefing, if that's what you're asking, are you asking as I became a minister, did I get, no, I didn't get a...
So was it very much a question of as and when issues came to your private office, you would then be expected to acquaint yourself with what that issue was, and there wasn't any kind of training, instruction, briefing formally provided at the beginning of your time as minister?
No, there wasn't any briefing or instruction given at the beginning of my time as a minister. Ministers are expected to go in and start work.
You've exhibited to your statement, I don't think we need to look at it, some of the occasions on which you'd either raised matters as a constituency MP or matters have come across or come to your attention as an opposition MP or as shadow spokesperson for health. Would it be right to understand that although you knew that people had been infected through blood and blood products, and you understood that that was an appalling thing, you didn't have any kind of detailed knowledge of the circumstances in which NHS treatment had infected thousands of individuals?
Could you be a bit more specific about what you mean by circumstances before I answer you?
So let me try and rephrase it. The documents you've exhibited to your statement show that you, for example, as a constituency MP, had raised matters relating to the position of those who had been infected. There's some, I think, correspondence with Frank Dobson in the late 1990s, for example. So you had undertaken the normal role of a constituency MP, raising matters of concern to your constituents. But did you have any particular knowledge of how it had come about that so many people had been infected with hepatitis or HIV in the 70s and in the 80s in particular?
Forgive me, in order to answer that question, I'd have to speculate about what I knew. And I'm not as clear on that as perhaps you would hope I would be. What I can only say is what my motivation would have been is that I understood that individuals had received a treatment for which there was high expectations within the health community, which turned out not to be the case. And as a result of that, infected and affected people suffered badly as a consequence. So I understood at least that point, and that I should pursue the questions that were being asked of me through to the minister responsible. And I did it first to Stephen Dorrell as Secretary of State, and then carried it across after the election of the Labour government. That, I think, would be the extent. I didn't have detailed scientific or a sequence of dates to understand how that happened. Is that what you're asking me?
Yes, thank you. Had you, prior to taking up your role as Minister of State in 2007, had you directly met individuals who'd been infected or their family members, as far as you can recall?
I would only be able to assume that in my constituency surgery, where I would have seen constituents, I would have met individuals there. I don't recall meeting representative groups or being asked to do that at any point.
And then during your time as Minister of State, first of all, to what extent, more generally, did you meet patients during that period, or representative groups of patient organisations?
As a Minister of State, obviously the duties are very wide-ranging, from signing letters through to reading policy documents, to undertaking visits, and to having a series of meetings. And every day would be full of meetings. The majority of those meetings would be direct engagement with the department or the relevant policy unit. For instance, if it was the Food Standards Agency, I would be meeting and dealing directly with them. I would meet, under some circumstances, groups that were directly connected to the department that wanted to express a view to me directly. But ministers are not necessarily, ministers are not regularly meeting with a whole range of individuals or people who would want to see them. There has to be some sort of way of dealing. It would be impossible to see everybody. But I can't say I never saw people. But
And during your time as Minister of State for Public Health, as far as you can recall, did you meet any of those who had been infected with hepatitis or HIV, or whose family members had been infected with hepatitis or HIV?
I'm afraid I really can't remember. We're talking about, over the course of my ministerial time, hundreds and hundreds of meetings, and they're all pressing. Forgive me, I can't remember, I'm sorry.
Can I just ask you a little then next, again, at quite a general level, about the extent of any interactions or dealings with the devolved administrations, either on public health generally or specifically relating to matters relating to blood policy? We'll see a degree of interaction with the Scottish Executive, Scottish Government, in relation to the Penrose inquiry, as we look through some of the material that you've referred to in your statement. But more generally, was there much interaction at a ministerial level with colleagues in Scotland or Wales or Northern Ireland on public health matters?
If it was required, I would be in contact with the minister in Wales at the time, I think was Edwina Hart, and with the health minister in Scotland, who I think to begin with was Nicola Sturgeon. That changed. There will be a range of issues that would affect all three of us that there would need to be discussion on, but it didn't arise that often.
And do you have any knowledge of the extent to which there was interaction at an official level on a regular basis between the Department of Health and the devolved administrations?
I'm afraid I couldn't comment on that, no. I don't know.
And then you'd come to the Department of Health, obviously, after a number of years at the Treasury. As Minister of State for Public Health, did you have many dealings with the Treasury in terms of bids for expenditure or budgets or the like?
No. The Ministers of State would pass information to the Secretary of State. Engagement with the Treasury, because it would be directly Secretaries of State to Chief Secretary. That would be the normal flow. It's you can't. No, I wouldn't directly as a minister.
Now, I'm going to start now by looking at the issue of engagement with or interaction with the Archer inquiry during your time as Minister of State. Now, obviously, again, the inquiry's heard the position from Caroline Flint from her time as Minister. If we could turn to ARCH 601, please. This is the Archer report published in February 2009, and we'll come on at a later stage of your evidence to your consideration of the recommendations in the report. But for present purposes, if we could go to page 10, please. Top of the page, this is what Lord Archer said in his report. The Department of Health maintained its view that the inquiry was unnecessary and declined to provide witnesses to give evidence in public. But they supplied documents which we requested, responded to questions from us, and sent representatives to 3 private, informal and unminuted meetings. Now, you were asked about that in your statement, and you explained that in relation to the necessity or otherwise for an inquiry, you inherited essentially an existing policy position, which was that a statutory public inquiry was not called for. And we'll explore that shortly. But in relation to the decision not to provide witnesses to give evidence, you've said in your statement that that had been a decision taken by your predecessors, so by Ms Flint and Patricia Hewitt as Secretary of State. Would it have been open to you, however, to take a different course and to change that decision? In principle. Could I have changed that? I would have had to have, I could if I could demonstrate, because I personally wouldn't make that decision. You're asking me to speculate what I could have done. Yes.
That's very difficult. I could have gone to the Secretary of State and asked that that be reconsidered, I think.
And did you ever, as far as you can recall, think about doing so?
The first thing I did was to ask for the rationale of why not supplying witnesses directly to Lord Archer's inquiry had been made. And it was explained to me, which I have explained
Yes,
in my
absolutely.
statement, the reasons, length of time, availability of those directly involved, no longer being with the department and the officials in place having not been connected to it. And therefore, the release of all the documents and the informal, as Lord Archer called it, discussions with those currently in the department seemed to me a reasonable way forward, and I accepted that as a reason. It came out later, post the Archer report, that Lord Archer was made a request to the previous Secretary of State specifically with regard to officials. He didn't mention ministers. But so, in theory, yes. In practice, I looked at the reasons that were given. I thought they were reasonable, and therefore I pursued a line of maximum disclosure and to be as helpful as possible within the constraints of the inquiry being a private inquiry, not a public inquiry, which you might want to come on to, the complications that presents as well.
It's certainly right that I think one of the reasons that was contained within the documentation that was provided to you was that the current ministers, current officials, wouldn't have a direct knowledge of decisions and events and the state of knowledge in the 1970s and 1980s, or even indeed potentially the 1990s. Do you know if the department ever gave consideration to itself proactively contacting former ministers, former officials, to offer support should they wish to voluntarily provide evidence to the Archer inquiry?
I'm not aware of that, no. And you will see in my evidence shortly after I became a minister, Dr. David Owen gave evidence to the inquiry, which was reported, and I received briefing on that, but that was in a sense of defending, explaining what had happened at the time. So in direct answer to your question, I am not aware that those efforts were made. No, I'm not. I won't go further because it's speculation, because I'm thinking into before I was a minister, and I can't answer that question.
And then, in terms more generally of the policy of the department that there should not be a public inquiry and that one was not warranted, can we look at a briefing from July 2007, so not long after you and Mr. Johnson had assumed your positions? It's at DHSC 5011228. We'll see it's dated the 19th of July 2007 from Linda Page. It's if we just go a little further down, we can see the purpose of this specific briefing is to brief the Secretary of State, who was due to be attending the Select Committee on Health. It was anticipated that the issue of a government-sponsored public inquiry was going to be raised with the Secretary of State at the Select Committee. If we just go up the page to see the list of those who were copied in, did this include your office?
Yes. I from recollection, I think Jackie, at that point, Jackie worked in my private office, yes.
And this isn't a question, but this is just an observation for the benefit of others. We can see the last three names are from the what's in brackets against each name. SEHD would be Scottish Executive Health Department, and then WAG and DHSS PSNI are the Welsh and Northern Irish administrations. So we can see at least this document being copied more widely. And then if we go to the bottom of the page, we've got lines to take as a heading, and then paragraph 4 reads, the line to take as agreed with ministers previously is, and then if we go over the page, and we have a broad summary of the line to take. The government has great sympathy for those infected with hepatitis C and HIV. The government has considered the call for a public inquiry very carefully. However, we believe the government of the day acted in good faith, relying on the technology available at the time, and therefore we do not consider that a public inquiry would provide any real benefit to those affected. So that's the broad line to take. If we could then go to the bottom of page 3, please, Lawrence. We've got the heading towards the bottom of that page, government-backed public inquiry, and if I pick it up at paragraph 17, successive Secretaries of State have resisted calls for a government-backed public inquiry into how patients became infected with hepatitis C following NHS treatment with blood and blood products prior to the introduction of heat treatment to eliminate the hepatitis C virus on the following grounds. And then over the page, we have a number of reasons set out, and I just wanted to explore some of those with you, Baroness. So the first bullet point says a full judicial inquiry would be a major, costly and time-consuming exercise that would depend on the recollections of witnesses about events that took place 20 or more years ago. This would make it difficult to construct a clear and detailed picture of what took place. Now, in relation to an inquiry being costly and taking time, those are fairly self-evident propositions. You say in your statement, however, that in your own mind, the issue of costs, although not irrelevant, was less weighty than some of the other factors that were put forward to you over the course of the 2 years you were in office. Is that right?
I did say that, yes.
In relation to the issue about the difficulty of constructing a clear and detailed picture of what took place, it might be said that's something of an assumption on the part of civil servants, because witnesses would have documents to prompt memory, which might help at least a reasonable construction of what took place. Would that be a fair comment in your view?
It is an opinion, isn't it? That could be constructed, but that wasn't the major bullet point that I was concerned with.
And then the next bullet point is this: an inquiry would not add significantly to our current understanding of how the blood supply became infected with hepatitis C, or the steps needed to deal with problems of this kind now or in the future. Now, again, that rather depends upon the extent of the department's current understanding of how the blood supply became infected with hepatitis C. Did, as far as you can recall, did you ever probe yourself what the current understanding was in order to ascertain what weight might be attached to this reason?
I think that bullet point is tied up with a wider consideration of how it occurred, how people were infected, and a wider question about the developments in health service care over that period of time. And so I think you will see in later comments that I make, because these are recurring themes,
yes.
I was trying to drill down, if that's a fair enough analogy, into how knowledge could or couldn't be expanded and how our understanding could be enhanced. And that occurs subsequently. So this is the first, so this happens, forgive me, I can't remember the date.
19th of July, so very early on.
It's very early
in terms
on.
Of your time
And it's a holding brief directed to the brief for the Secretary of State. So, to be honest, you're asking me about bullet points that demonstrated in my evidence that actually I required more information to sustain that observation that's there at bullet point 2.
if we look at bullet point 2, the assertion an inquiry wouldn't add significantly to our current understanding of how the blood supply became infected with hepatitis C, and then we look at I think it's the 5th bullet point, no evidence that wrongful practices were employed. It's right to understand, isn't it, that this is ministers being told by departmental officials, essentially, we know what happened and we don't think anything untoward or wrongful took place. Now, it might be said there's an element of the department marking its own homework, or to paraphrase a rather more famous phrase, they would say that, wouldn't they? I mean, do you have any observations on that, Baroness?
The department had, before I became a minister, undertaken 2 detailed pieces of internal work, which was then published and made available to the Archer Inquiry, the documentation. And so that is a view that they are expressing to the Secretary of State, yes. But that predates my tenure as a Minister of State,
yes.
Those 2 reports.
And in terms of those reports, I think it's right to understand, and there's no criticism implied by this question, Baroness, you presumably wouldn't have had any knowledge yourself of how rigorous or comprehensive or accurate those exercises were.
Well, I would need to jump out of time sequence to answer that question, if that would be okay.
Yes.
If you look at the response to from Liz Wooderson to me in 2009 sometime, as a result of Patient Wilson's comments to me, she talks in terms of the department has deployed staff for over 2 years trying to find some of the missing papers, categorising all the ones they had, and that it had been considered, I can't remember her exact phrasing, forgive me, several times by lawyers. So I think that the department was of the view that there were grounds for thinking that, and they held the line that the treatment was given in good faith with what they knew at the time.
The 3rd bullet point is that a public inquiry could undermine public confidence and affect the donor population, thus putting at risk the supply of blood to the NHS. Was that something that particularly you found particularly persuasive?
I don't recall that bullet point appearing again. I'm not sure that now I would agree with that proposition. It's public inquiries are very important, goes without saying. I don't accept that point myself, but I'm doing it from a position of I would need more justification before I accepted that line.
And I think you're right. I don't think that does appear, at least not prominently, in any of the later material.
No.
And then the next bullet point again really picks up on the issue of resources, and then some issues relating to the current payment schemes. And we'll look at the position in relation to the payment schemes, I think most conveniently by reference to the response to the Archer report. If we just look at paragraph 18 before we leave this document, it says this: there are a number of examples of countries such as France, Ireland and Canada where trials/inquiries have led to large compensation amounts. The circumstances are different as fault was determined, though the lobby groups do not make that distinction. Now, the inquiries heard some evidence to suggest that a factor in opposing a public inquiry from the Department of Health's perspective might have been the fear that it would indeed lead to large compensation payments and a desire to avoid that. Was that something which you were conscious of during your time in office?
Sorry, do you mean that the department was motivated by compensation payments, not by,
Yes.
and that used that as the overwhelming reason for not wanting a public inquiry?
The inquiry has heard some evidence to suggest, or it might be submitted suggests, that a real reason why the department consistently opposed a public inquiry was the belief that it would lead to, as it had in other countries, recommendations for substantial compensation, which the department did not want to have to pay.
No, that wasn't. That's not something that is an impression that I have. My impression, my evidence shows that it's the question of fault liability, which has wider implications. So I don't think so, no. I'm sure I'm not answering that question very adequately, but that was not my impression at the time.
Can I then ask you to look at a document which is a letter from you to Norman Lamb MP. It's at DHSC 6548448. It's undated, but we can see from the top, it looks like it's a letter sent in 2007, and it's responding to a letter of the 30th of July, so presumably the 30th of July 2007, to Alan Johnson. Now, first of all, if we just scroll down the page a little, evidence that the inquiry has heard from other ministers, it has explained that generally these types of letters were not drafted directly by the minister, but would be drafted by officials within the department on behalf of the minister. Would it be right to understand that, again, this would have been the text of a letter supplied to you for you to approve?
Yes, that's correct. I wouldn't have written this letter. It was drafted for me.
And then we've got the general line to take in the second paragraph about sympathy. The third paragraph refers to interaction with the Archer inquiry. The next paragraph refers to one of the reviews, the internal reviews that you've spoken about. And then we have the last paragraph on the page, which says this: turning to your comments about the Republic of Ireland, it has never been established that any wrongful practices were employed in the UK, which is why successive governments have concluded that a public inquiry is not justified. Now, just pausing there, it could be said that there's an element of circularity about that reasoning, because without a public inquiry, how is anyone to establish that wrongful practices were or were not employed? Do you have any thoughts on that?
I'm trying to be fair and answer your question, if I can. For a public inquiry, in my mind, for a public inquiry to be called, there's criteria, albeit non-specific, but that something is not right, something has gone wrong. And so the question of wrongful practices is about, was there a reason that meant that a further, more detailed consideration, a full public inquiry, was the way forward? I can see the point that you are making now. Hindsight is good. But at the time, the department was holding to a line with evidence given to ministers, justifications given to ministers, that there wasn't a fault, it wasn't deliberate, there hadn't been errors. It was the best. They based it on the best information they had at the time. I'm not sure that quite answers your question, but I don't feel that your direct proposition is a bit more complex than that, to be frank.
We may pick up, I think, the essential point you were there making, as I understand it, and please correct me if I'm wrong, Baroness Primarolo, is that irrespective of the wording of this letter, is this right? You're saying that for there to be a public inquiry, there would need to be some cause for concern, that there were things that needed investigating.
I am only referring to how I personally think. It's not for a Minister of State to call a public inquiry, Secretary of State probably to Prime Minister, and that it's quite a high bar to get one, and it tends to revolve around this question of liability, and that's what I'm saying. It's a very complex series of considerations that do not fall directly to a Minister of State, although, as you can see, inevitably I was involved in the managing of the policy.
We'll come back to that a little later in your evidence to some of those issues. I just want to then look at the next sentence with you, which says this: donor screening for hepatitis C was introduced in the UK in 1991. Correct so far. And the development of this test marked a major advance in microbiological technology, which could not have been implemented before this time. Now, the inquiry knows, and the department knew, that there had been a judgment of the High Court in 2001 under consumer product legislation, which concluded that screening for hepatitis C could have been introduced earlier than it was. So this statement appears to be, and it's not the first time the inquiry's seen it in material, incorrect. Did you have any knowledge of that at the time?
I don't think I did. I would have signed a letter drafted by the relevant policy divisions, and I would expect that to be accurate. I would not be expecting for the Minister then to check whether what was in it was accurate or not. I would assume that it was. I have to work on that basis. I know I don't offer this as an excuse, but for a minister, I would have received hundreds and hundreds of bits of paper every day and be signing a large amount of letters. And I felt I should be able to rely on what the department is telling me is correct. Unless they've made a mistake, which they have to then own up to, and it has to be corrected on the record.
Now, I want to move next chronologically to 2008 and the announcement of an inquiry to be held in Scotland. So if we look, first of all, at WITN 5494109. If we go to this, oh, no, that's not it.
No.
WITN 5494, I'm sorry, Lawrence, 019. My fault entirely. And if we go to the second page, we have a clearer copy of the document. So we can see this is a briefing 5th of March 2008 from Patrick Hennessy to you, MSPH. And if we just look at the first paragraph we can see it says, this is to advise you that the Scottish Government intend to announce a public inquiry into the contamination of blood and blood products with hepatitis C and HIV in the 1970s and early 80s. It's likely to be announced by the end of March. We're awaiting legal opinion and we'll send a full submission covering options for the UK Government when this is available. And then if we just look at the bottom of the next page, please, Lawrence. Paragraph 12, bottom of the page, under the heading Line to Take. In the event that an inquiry is announced before it is possible to consider fully the UK implications, our line should be that. And then over the page, we're seeking legal advice on the implications for the rest of the UK on the Scottish Government's decision. We've already released all the relevant documents held by DH into the public domain. If we just go back to page 2 then of this. I just wanted to look at the handwriting at the top of the page. Thanks. So someone has written, a further submission with legal advice will follow. However, Scotland's decision could significantly weaken our lines, which may be coupled with the imminent publication of Lord Archer's review. And then on the left-hand side, it says, officials have advised that we would have a good legal case for not joining the inquiry. However, they're concerned re-handling implications/risks, re-highlighting devolution tensions, and are concerned this may become politically sensitive and as such as seeking an initial steer as to whether you are still minded to retain our current position. Your initial views are sought before Friday. So that's the document that you received, and you were asked to provide an initial view. If we just go then to WITN 5494020. As I understand it, this is from you.
Yes.
In response to the invitation for an initial view, and you say, for now we should hold our line. We are not underlined to join Scottish inquiry. Officials must keep events under close scrutiny and report back regularly so that I can keep our position under review. Now, it would appear clear in terms that that was an initial position and you were proposing to keep it under review. But can you recall what your own thinking was in terms of, reasonably emphatically, you underline not, we are not to join the Scottish inquiry. Why was that your initial thinking?
Because I should hold at the government's current policy until I had further advice on whether, for example, issues came to light that made it clear actually that we needed to think again about our commitment to not hold a public inquiry. Also, the situation with regard to Scotland arose in two very specific circumstances. One, the manifesto commitment for the SNP, and secondly, the ruling with regard to the judgment with regard to, I think, was it Article 2 of the ECHR?
Yes.
And so the question was that relevant to England and Wales as well? I'm not a lawyer, so I needed advice on it. What I expected, and as you say, my words speak for themselves, I wanted everybody to keep a close eye on it in case something did come up that I needed to take more advice on.
And then the fuller submission that you have been promised in this submission came on the 1st of April. So if we just look at that, DHSC 0038592_075. We see the date at the top of the page. Again, it's from Patrick Hennessy, and we can see that it's directed to you and to Hugh Taylor. And then, before we look at the handwriting, if we look at the text, first of all, under the heading Summary, This is to advise you about the announcement on the 23rd of April of a public inquiry in Scotland. We recommend that you maintain the position that an inquiry in England is unnecessary. And then there's a reference to legal opinion supportive of that position being attached, and a background note also attached. We'll just go over the page, please, to page 2. We can see towards the bottom of the page, we've got pros and cons for the UK government of joining the Scottish Public Inquiry. And then there's the heading advantages of joining the Scottish Inquiry, and the advantage is said to be that UK government could have some influence over the proceedings, in particular the scope and identity of the inquiry panel. And then the second advantage is initial reaction from stakeholders and the media would be likely to be favourable, although such a change of direction would inevitably attract comment. And then disadvantages of joining a Scottish inquiry. We go to the next page. This is really what I wanted to ask you about. So public inquiries are very costly. The costs are not easy to control. We've addressed that already. That was obviously part of the briefing that Alan Johnson had already received. Then this, the UK government would have little influence over the direction of proceedings once the inquiry was established. Now, that's almost certainly right. Public inquiries are intended to be independent of government, but why was that a disadvantage? Isn't that just the natural consequence of a public inquiry?
Yes, you're asking me about comments that are in papers with whether or not I put whether I put any store against those points.
Yes, or inviting your comment on them now, looking back.
Should I be using hindsight now? Well, it's a view that was expressed. My view with whether or not we should join or would be required to join the Scottish inquiry was based on a slightly different view. There were obviously constitutional issues, and I suppose, no, I'm not going to use that word. If we should hold a public inquiry, there should be grounds for us holding it, and we should decide to do so. And I understood that the Scottish inquiry was very specifically to do with Scotland, and therefore that England and Wales should not join that inquiry because the point of law didn't pertain to us. That's what I understood. I have to be honest and say I'm struggling with you putting points to me that I can see them on the page. I could pass a comment on them, but in terms of what I was focused on in this particular piece of work were slightly different questions.
These are the reasons that are being given to you
Yes.
from the perspective of officials as to disadvantages of joining the Scottish inquiry, and you're absolutely entitled to say your own thinking was perhaps slightly different or different in its emphasis and focus. But in part, Baroness, I'm exploring this with you because it may provide some insight into your officials' thinking at the time. And short of calling every official to give evidence, inviting your thoughts perhaps is a useful shortcut. The next 2 bullet points are UK government...
Sorry, could I just ask you,
Yes.
is it, if you're asking me to speculate, the speculation is about the terms of reference of the inquiry, which, forgive me, I'm not familiar with how they're determined, but there would be some views expressed by the department if there was a full public inquiry that the department had called for. Would that not be the case?
Yes.
And it is possible, there is another reading of that. That's not for me to speculate, but nor do I see necessarily there's a motive behind that is obstructive.
The next 2 bullet points as a disadvantage is UK government ministers, officials and NHS bodies from England may be summoned to give evidence. And then the next is that the recommendations would apply to the UK. Now, did you see either of those as reasons not to join the Scottish inquiry?
No. If there's an inquiry, then those two bullet points follow. The question is whether the Scottish inquiry and why, excuse me, it had been established, given the issues around devolution and the complexities with this, was something that the department should agree to enter the inquiry. That's a different set of circumstances I think I was concerned about at the time, but it stands to reason. If there's a public inquiry, give evidence if you're required to.
And then if we just, I think in fairness, look at paragraph 10, that picks up on the 2 points that you've referred to in your evidence. It says here, this is a Scottish inquiry in response to a policy decision of the Scottish Government as set out in their manifesto and a legal decision applying to Scotland, which the Scottish Government has chosen not to contest. If we just then go to the first page of this, just to see your response. So we need to look at the handwriting for this. This, I think, is probably from your private office to you. This is to inform you of the public inquiry in Scotland to be announced 23rd April. Given that the existing position has not changed and our position is supported by legal evidence, there seems no reason to change our position. Given your previous steer, I assume you're content for the government to stay out of the Scottish inquiry. And then if we just go down, we can see agreed,
Yes.
and that's your confirmation on the 17th of April.
Yes.
And if we then, I think, go to your witness statement, WITN 5494001, page 37. You have set out in paragraph 340 the factors that you think would have persuaded, or the factors that would have most inclined you to agree not to join the Scottish inquiry. The first refers to the case in Scotland. Then you say there's no new evidence showing lack of good faith by previous governments. There have been court cases and a settlement when the evidence would have been considered. The development of policy and procedures for blood and blood product safety have continued to take a proactive approach to ensuring these treatments were as safe as was scientifically possible. And then clinical practices towards patients in the NHS have been transformed to ensure patients are kept well informed about their treatments. Now, I just wanted to ask you about that last point, because the reference there to transformation might suggest an understanding on your part that the patients who had been affected by this issue had not been kept well informed about their treatments. Was that your understanding at the time, as far as you can recall?
No, that wasn't my understanding. That comment is in recognition that clinical practice has changed, duty of candour, how much doctors disclose to their patients. That was a comment about now. I wasn't projecting it into the past, if that's what you're asking me.
Yes, again, the question of what you did or didn't know about clinical practices towards those affected by these issues is something I want to come back to at a later stage.
Okay.
Can we then just pick up a submission in November 2008, which is at WITN 549494. So we can see, sorry, it's not a submission so much, it's lines to take on the inquiry, that's the Scottish inquiry, and on current actions on hepatitis C. And then we can see this, the handwriting at the top. This is the media handling for your approval if the judge in Scotland decides to effectively widen the inquiry. And then there's reference to a further submission coming, and you say agreed. Bottom of the page gives us the date, 20th of November 2008. If we just go over the page, we can see the issue in bold print. A judicial review in Scotland is considering whether to extend the scope of the public inquiry into the deaths of 2 patients from hepatitis C by requiring the participation of a UK government minister, the Advocate General for Scotland. This would effectively widen the scope of the inquiry from Scotland to the UK. Now, I'm not going to go through the detail of that with you. Your statement is referred to the various documents, but just so that we can understand why this particular set of lines to take were being produced. If we just go to the 3rd page, please, Lawrence. Why won't the government agree to a public inquiry in England? It says, we've considered the call for a public inquiry in England very carefully. However, as with previous administrations, the government does not accept that any wrongful practices were employed in the NHS at the time and does not consider that a public inquiry is justified. The NHS took appropriate steps with the knowledge and technology available at the time. And then we have essentially 4 assertions. Heat treatment of blood products introduced through 1985. Screening of blood donations for HIV introduced October 1985. Screening of blood donations for hepatitis C introduced September 1991. Each of these was a significant step forward in medical science and could not realistically have been introduced in England before this time. Now, again, the reason I'm flagging that up, Baroness, is that it may be said that that assertion that none of this could realistically have been done at any earlier stage was not correct. Or at least that the position was rather more complicated than it might be thought from the way in which it's set out here. Would it be right to understand that you would have no direct knowledge of your own with which to subject these kind of statements to critical analysis, and you'd assume that what officials were telling you was correct?
I did assume that I was being given the correct information, and the relationship between ministers and officials is based on mutual respect and trust. They do their job and the minister does theirs. So yes, I had no reason to believe that that wasn't the correct information.
I'm going to turn next to the response to the Archer inquiry report. If we pick it up to start with in your witness statement, so if we have the statement back on screen, please, Lawrence, WITN 5494001, and if we go to page 58. So we can see there the date of the report, 23rd of February 2009. So it's now the last few months of your time as Minister, although you wouldn't have known that presumably at the time, and Lord Archer's report's published in February 2009. Now, I just want to read what you say on the next page at paragraph 3.87 before we then explore some of the documents. You say this in paragraph 3.87. I was disappointed and frustrated with the options provided by officials in response to Lord Archer's recommendations. As can be seen in further detailed exchanges between myself and officials, I had hoped to be able to respond more positively to some of the issues identified in the inquiry's recommendations. For example, by removing the inconsistencies in qualification criteria for payments between the different trusts. So we will look at some of the detailed exchanges that you had on this issue. But that's an accurate description, is it, overall of how you felt about the submissions and briefings and suggestions that were coming to you?
That was my response, specifically to the first submission I received from officials following the recommendations being published. Yes, I did feel frustrated.
And if we just look at the initial submission that you received, it's at WITN 5494033. We can see it's from Rowena Geacock, directed or addressed to you, dated the 24th of February 2009. The purpose is said to be to inform you of the recommendations of the Archer report, which was published yesterday, and to give an initial view on actions needed before the government can respond. There's then, if we go towards the bottom half of the page, a summary of Lord Archer's recommendations, and just so that we can follow the rest of your evidence, I'm not going to be asking you about each of these, but the summary of recommendations was establishment of a statutory committee to advise government on the management of haemophilia, free prescription drugs, free access to other NHS and support services, secured funding by government for the Haemophilia Society, review of the current ex gratia payment system, including bringing payments in line with those in Ireland, very much higher than in the UK, and incorporating them within the DWP benefit system, enabling haemophilia patients to have access to insurance, and establishing a look-back exercise to identify any remaining patients who may have been infected and may not be aware of this. Now, we'll see how those various recommendations are addressed in the submissions, but I'm going to be concentrating on the issue relating to the payments system in terms of detail. And then if we just go over the page, this follows a heading which is initial reactions on recommendations, and then we can see the proposal to establish a committee. There's a suggestion that there would that they don't see the rationale for it being on a statutory basis. Free prescription drugs will need to be considered in the light of exceptions for other long-term and hereditary conditions. Secured funding for the Haemophilia Society needs to be considered, it said, in the light of funding of the third sector, might open the door to other third sector organisations to ask for equivalent support. Review of payment system says we need to consider and carefully cost, but then it says the financial implications are enormous. Access to insurance will seek the view of the Association of British Insurers. Look back exercise, there's already been one in the 90s. If it were decided to carry out a further search, we would propose asking the UK Haemophilia Centre Doctors Organisation to manage it. So those were the initial recommendations coming to you, and that's what you found to be disappointing and frustrating, is that right?
Yes, I didn't consider those recommendations or options, and maybe my expectation was too high, but I did expect to be offered some options in order to progress the recommendations.
And if we go back to the first page, there's handwriting towards the top. It's not the very top bit of handwriting which is addressed to you, but it's the bit which says this report is poor, I think, and then it says see attached note for further urgent action. That's from you. And what you've said in your statement is when you're saying this report is poor, you're not referring to the Archer report. You're referring to a note received from an official. I don't know whether it's this note or one of the other notes, but that's what your statement tells us.
Yes, I believe that is the case, in that this is I think this is the first note I received from officials from the Archer inquiry, which has is reported a year after initially thought it would. I expected options.
And then perhaps before we break, just one further document. which is a DHSC 5561472. This is an email exchange, 25th of February 2009. If we go to the second page, it's an email from Elizabeth Woodson, 25th of February 2009, and then we can see it's sent to various officials within the department dealing with blood policy matters, not, I think, to your office. Is that right?
No, I don't think it was to my office. I'm just reading it now.
And you've said in your statement that you don't think it was copied to your private office. And then Ms Woodson says this: well done for getting a submission up so quickly on this. It's frustrating not to be there with you to help. And then she says, my reading of Archer's recommendations are that, and then I'm not going to read those out. Next paragraph, she says, so on the whole, the report looks like something we wouldn't want to spend a lot of time on. I would have thought it would be best, therefore, to aim to do only a brief response and get it out there as quickly as possible, perhaps in about a month. The response should basically set out our side of the story, all the steps taken to make the blood supply safer as soon as it was recognised there was a problem. Say we are pleased Archer recognises this, if I'm right that he doesn't find fault with government actions at the time. Set out all the services we provide for haemophiliacs and the compensation scheme. Anything else positive we can say about what we're already doing. Politely reject the specific recommendations. Obviously, it would be great if we could think of something to give them, and we will need to think about that. The most likely, I should think, is the free prescriptions given. That view being expressed by Ms Woodson is essentially not to devote very much further time to considering the Archer recommendations. And that you didn't see this at the time. What, if anything, would you have to say about it looking at it now?
I don't recall seeing it. That is her expressed view. That wasn't mine as the minister. And I pursued with the team, as you said, we'll look at it, every possible way we could respond positively, because I believe that was the right thing to do. I can't say anything about her email, frankly. I can only account for what I was doing, I think.
And we'll pick up that and your own further requests to officials to do more work on this issue after the break. Sarah, I note the time.
Yes, well, we'll take a break now until 10 to 12. This is the first break. At this break, and indeed at any break, you must remember that you're under oath, and that what that means is you may not discuss what you have said in evidence or what you think you may yet say in evidence with anyone, whoever that anyone is, but you can talk about anything else you like.
The weather, thank you.
10 to 12.